The IDEA has not been revised since 2004. So much of the science and what we know about behavior over the past 16 years has not been updated. Now, we do have case law to guide us, but it's not consistent across the federal appellate courts. So behavior is one of those areas within the law that remains an area of frequent disagreement, confusion, misinterpretation, and a huge trigger of the dispute resolution options under the law, which include due process, mediation, state complaints, OCR complaints. So when it comes to the student code of conduct, there is an unfortunate reality. A school district doesn't have to write everything down it might consider inappropriate behavior. So it typically reserves the right to create violations that it deems inappropriate. Now, students not left without recourses. A school district does need to have notice of a policy, and they must provide that to the student. And that would include potential conduct violations, even if they're not written down, or if they're verbal, or if they're informal policies or just made up last minute. There are instances where the courts have struck down board policy because it's too vague, does not provide sufficient notice, violates state law, or violates constitutional rights. So it's always wise to consider whether your child's constitutional rights are being violated, whether state law has been violated, and then also keep in mind that if state law allows for something that the school is trying to prohibit, they can't do that. Okay? And under the federal law, if you're engaging in a protected activity, the school cannot infringe upon that right. That's retaliation. So a student with an IEP or 504, as a general rule, can be disciplined according to the school code of conduct. In fact, this is the case for the overwhelming majority of IEP and 504 students. They make up the majority of IEP and 504 students. So that's in direct contradiction to the exaggerations and myths being bandied about by schools and the media, claiming that special education laws are preventing schools from disciplining special education students and forcing schools to keep disruptive students in the class. The facts just don't support that, nor the numbers. Now, to show how archaic the IDEA's 2004 provisions are when it comes to behavior, the IDEA only mandates the creation of a behavior plan in one spot. And that's when a child is at risk of a disciplinary change in placement and a team determines that the behavior or conduct is a manifestation of their disability. But the absence of additional mandates or specific language in the federal law doesn't mean that we don't follow best practice, federal case law, state regulations, board policy, and then also you throw in historical practice. And all of those things are chock-a-block full of requirements on addressing behavior inside the school setting. Now, in 2017, the Supreme Court replaced the Raleigh decision, which was governing what the definition of a free and appropriate public education was. So in the Endrew F. decision in 2017, the Supreme Court drew a clear correlation between the student's inability to make tangible gains on IEP goals over multiple school years. Why? Because the school district failed to properly address the student's maladaptive, which is the same thing as inappropriate, bad behavior that was impeding his ability to learn. The court believed that through a good FBA, an appropriate behavior plan, that the student would have progressed in his other goals. This is a significant acknowledgement in special education where ambiguity once existed, because it rightfully clarifies a school's legal duty beyond the narrow scope of just academics alone. Now, it's always been there in the law, but not highlighted on an equal footing with academics like the Supreme Court decision in Endrew F. did. It was a very, very big game changer if we learn how to apply it on our IEP teams. It's all for naught unless we learn and understand how to apply it. So a behavior plan is supposed to be a set of positive behavior interventions and support designed by the child's IEP team to address behaviors impeding the child's learning or impacting the learning of others. Now, as an aside, inattentiveness, distractibility, sleeping in class, work refusals, work avoidance, deficits in self-awareness and self-management. These are all behaviors that impede learning. Schools frequently ignore it and they overlook it. They shouldn't. Any of these things, it should be considered for a behavior plan, behavior goals, behavior services. Now, is an FBA required prior to developing a behavior plan? No. But there is a heck of a lot of case law and hearing officer decisions where behavior plans have been deemed inappropriate and a violation of FAPE because they weren't developed properly using a good functional behavior assessment. So the key to an appropriate behavior plan is one that accurately identifies the behavior, explains thoroughly enough what triggers the behaviors and what needs to be done to eliminate the behaviors, prevent it from occurring, or lessen their impact in the environment. Now, this is best done through an FBA that includes observations, direct observations, in the environment where those behaviors are occurring. That's where you want to conduct observations. So the law explicitly requires positive behavior intervention. Now, the flip side, it doesn't specifically outlaw or prohibit the use of negative or punitive consequences. Now, many schools will make the mistake of creating punitive behavior plans or plans that require the student to follow the student code of conduct as it's written. And yes, technically they can do that, but doesn't make the plans appropriate. And according to the Endrew F standard of FAPE, it may create a violation if the parents choose to challenge it. So at the end of the day, the behavior plan was initially envisioned as a means to keep the student in a general education setting through reasonable flexibility and consideration of what the student behavior needs are. We know that skill acquisition goals need to accompany behavior intervention plans to work effectively and meaningful for both the student and the staff. Just accommodating behavior doesn't work. So it creates staff frustration and also perpetuates these myths of a bad student. So always remember that behavior is an education and performance area within the category of social emotional development. And an appropriate behavior plan is one that identifies triggers of the behavior, incorporates positive behavior interventions with responsible staff being trained to a level of competency so that they're implemented without error. Now, this is the biggest problem with behavior plans. Now, it's a failure by administration and educators to do it right, to do it competently, to do it without error. So for them to be receptive to training and following the plan as is adopted is the key to success. These are all preventable issues.